to go?
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Okay, if you're not in the first argument, please turn off your cameras and mute your microphones. Thank you.
Good morning, everybody. We're glad to have you with us. Our colleague, my name is Diana Motz, and the other judge that you can see is Judge Floyd. Our colleague, Judge Rushing, is just on the phone, and she will, though, of course, participate in oral argument. We're happy to hear argument in our first case, number 20-1743, Amazon versus WC Holdings. Counsel?
Good afternoon. May it please the court, George Calhoun of IFRA PLLC for the appellants Brian Watson and WDC Holdings. Your Honors, the core of Amazon's complaint is a theory that the defendants conspired to fraudulently induce Amazon into real estate development or purchase contracts. Amazon admitted in the district court that its claims rest on defendants' fraudulent inducement of Amazon's approvals of these contracts. And while the precise nature of Amazon's claims continues to shift, it's amended its complaint several times since the granting of the preliminary injunction. It's very much adopted a kitchen sink approach, but it has not brought a single fraudulent inducement claim, and it does not seek rescission of any contract. It's expressly ratified the contracts and continues to enjoy the properties that are the subject of the underlying transactions. What Amazon is seeking, at least as to the Watson defendants, is to recover all payments that were made to or from the North Star defendants in connection with the development of these properties. But there's one critical point that I don't know if came out well in the briefs, and I wanted to make sure that that was clear, is that if a plaintiff is damaged by a fraudulent inducement, as Amazon alleges, under Virginia law, it must seek either rescission or to pursue damages. And Virginia law is expressed that if a plaintiff in that situation chooses damages, the damages are the delta between the value of the property at the time the contract was made and the value of the property that it would have possessed if the alleged misrepresentations had been true. That's from the Kleiber versus Freemanson Associates case. It's 587 Southeast 2nd, 555, which this court cited approvingly in Sharma versus USA International, 851 F3rd 308. And the reason that's important, Your Honors, is because, as the Virginia Supreme Court made clear, if a plaintiff does not allege facts to support a conclusion that the actual value of their property at the time they purchased it was less than the values of those units would have had without the alleged fraudulent acts, then that's grounds for judgment in favor of the defendants. As in Kleiber, here, Amazon makes no such allegations. There's nothing in the very voluminous preliminary injunction record before this panel that says what the value of this property is or would have been absent the alleged misrepresentations or fraudulent acts. If Amazon paid a market price for the properties that are at issue, if it's paying a market price rent for properties that it is indisputably keeping and enjoying, then it's not been harmed. And that.
Well, of course, Amazon doesn't have to make the claims that you would like it to make. What it's made is a claim of unjust enrichment, hasn't it?
It has brought a claim for unjust enrichment, Your Honor, and it's, in our view, woefully defective for a number of reasons. So for an unjust
excuse me, but the argument you were just making doesn't go to that, does it?
It goes to all of these issues.
That you think there's a problem with.
I'm sorry, Your Honor, I couldn't hear you.
I say it goes to something else that you think that Amazon has asserted and that you have a problem with. It doesn't go to Amazon's unjust enrichment claim, does it?
I think it goes all of it because their theory is all of their claims rely on this fraudulent inducement underpinning. But if you look at just their unjust enrichment claim, Your Honor, it suffers from other defects. One, Amazon has not put forth any evidence, no contentions, that it conferred a direct benefit onto these defendants. Amazon did not pay a penny to these defendants, much less $21.25 million, which is what the district court ordered to be placed in escrow. Amazon has not made a payment. I just want to make that very clear to North Star or Watson. Moreover, all the monies that were paid North Star and Watson, development fees and the like, were paid pursuant to contracts with third parties. And we've cited the law in our briefs about why that doesn't give rise to an unjust enrichment claims. The funds were paid as of right. Moreover,
Mr. Calhoun, I must have missed something. I thought probably the gist of the issue in this case is whether they can maintain a private civil RICO action and obtain equitable relief. I thought that's what you were fighting over.
Thank you, Your Honor. That's part of the problem with the kitchen sink approach. There's so many claims floating around here. I think that issue is one that is clear. Although this court has not come down definitively on whether a private litigant is entitled to injunctive relief under RICO, it has suggested that there's substantial doubt on that issue. The district courts in this circuit have said that a private civil litigant cannot obtain injunctive relief. We think the law on that is fairly clear, and that's supported by the text of the statute, which does not provide for injunctive relief in favor of private RICO litigants.
Well, do you think they've pledged sufficiently fraudulent practices that would support a RICO claim?
No, Your Honor. We think they've got a number of deficiencies in their RICO claims. For example, they've changed over time. I don't know if Your Honors have looked at their most recent complaint, but they've alleged effectively a single victim, limited time fraudulent enterprise is what their allegations are. Under this court's jurisprudence, that typically would not be enough to rise to a civil RICO. It would be an ordinary fraud claim that would be heard in state court. We think the allegations concerning the scope of the enterprise are insufficient. They've effectively alleged a hub and spoke with no wheel to connect the alleged hubs and spokes. So there's a number of problems with the civil RICO merits allegations, aside from whether, even if they had alleged an appropriate RICO, that they would be entitled to this extraordinary injunctive relief. The other issue of the RICO claim, Your Honor, in addition to it dovetails with the availability of injunctive relief, is disgorgement is also not available to a private civil RICO claimant. Frankly, Your Honor, I don't think disgorgement is appropriate to justify a injunction of this type in any case. Disgorgement is a punitive remedy. That's not appropriate for a pretrial injunction that's effectively a prejudgment attachment.
Mr. Calhoun, this is Judge Rushing. Just to clarify for my sake, that the injunction doesn't rise or fall with the RICO claims, right? That's one ground for the injunction request. But the district court, I thought, said because there were equitable claims here on which there was a likelihood of success, that he could enter an injunction on that basis as well.
Yeah, the distinction between whether the district court was issuing this injunction based on the RICO or the equitable claims wasn't terribly clear, Your Honor. Judge O'Grady did reference that there were equitable claims that were brought. We don't think any of those equitable claims are anything but pretext. And we think, frankly, none of them establish a likelihood of success on the merits. One of the
that was the whole part of the discussion for Grupo Mexicano, right? There was no need to discuss that if the basis for the injunction was just RICO. The whole Grupo Mexicano discussion had to do with equitable claims.
Correct, Your Honor. And the big failing with respect to those equitable claims, I mean, there are technical issues that all of them fail.
Counsel, excuse me just for a minute. To go back to Judge Rushing's original question, though, that the district court relied on those equitable claims as well as the RICO claim in granting the preliminary injunction, right?
I think, Your Honor, that Judge O'Grady just relied on the equitable claims.
Oh, well, then why are we talking about the RICO claim at all?
Amazon has argued that it's entitled to relief under RICO, but I think it's an attempt to backfill.
Well, I had thought that you had said, well, never mind. I guess it doesn't matter. I thought that you had said in response to a question from Judge Floyd that the case was all about the RICO claim. But at least the case in front of us isn't all about the RICO claim, because what is in front of us is whether there's a grant of preliminary injunction or not correctly granted here, right?
That's correct, Your Honor.
And you're representing to us that the RICO claim was not a proper basis, was not a basis the district court gave for granting the preliminary injunction.
The district court discussed the RICO claim and its analysis of likelihood of success, but then it stated that RICO didn't apply because there are equitable claims present, and didn't expressly say I'm issuing this under RICO or under the equitable claims. That's why we've argued both aspects of this, Your Honor.
Okay.
And the reason, the main reason, although there are a number of technical reasons we think those claims are deficient under state law, under this court's reasoning in the SAS case, that the equitable claims fail is that in order to obtain equitable relief, the plaintiff has the burden to establish an equitable interest in particular property. And that's totally absent from this preliminary injunction whatsoever. Amazon has not pointed to some property that it paid or a corpus or a race of any sort and said, that's ours. We paid that and we shouldn't have had to. What they've done is simply say, hey, Judge O'Grady, order these defendants to marshal assets and put $21.25 million into escrow. There's been no effort to trace or identify specific property. And that's what this court said is required. Excuse me, it's not SAS. This is the U.S. Rahman versus Oncology Associates case, in which this court was clear that in order to have an equitable interest, you had to identify the property in which you have equitable claims. That's totally absent here. So, and that's a necessary element of both conversion claim, the debt new claim. With respect to the unjust enrichment, similarly, they have to identify the benefit that they conferred on the defendants. They haven't done that. Whatever sums were paid to the defendants were not paid by Amazon. So if there were an unjust enrichment claim here, it's not Amazon's. And they made no effort to determine that the property that they received was not of an equivalent value to what they paid for it. I have a limited amount of time left. I did want to address the balance of harms issue because I think that's also a critical issue, Your Honors. The basis for this injunction expressly was to preserve a fund for payment of a remedy if the defendants were rendered insolvent by judgment. This court, in a number of cases, has said that injunctions of this sort should be narrowly tailored. The district court, in our view, failed to adequately consider the harm to the defendants. In fact, essentially said the fact that it would be rendered insolvent doesn't help the defendants. But the order itself presents a fait accompli. Unlike the limited cases where this court has approved such an extraordinary injunction, this was not simply an injunction prohibiting the defendants from transferring their assets. It ordered them to marshal assets and put it to an escrow account. That's equivalent to entering the judgment before trial and imposing the sentence before trial.
Mr. Calhoun, this is
Yes.
Judge Rushing again. I didn't see in your briefs any discussion of the bond option. It seems that a bond would require much fewer assets to be marshaled to satisfy this injunction. Can you discuss that?
We were hopeful that that would be the case, Your Honor. Unfortunately, all the bonding companies were requiring that 100% security, so it effectively made no difference. And I don't know if you've looked, Your Honor, if you looked at the assets, the largest assets of WDC and Mr. Watson are real estate or real estate development projects. The largest asset of WDC Holdings by far are its interest in the Amazon properties. In order to fund the escrow, would have to sell those properties, would not be able to get that property back.
So when you say 100% security, do you mean they want that liquid? They don't just want a security interest in your real property?
They wanted assets either deposited or secured at 100% level that we simply couldn't do. And we presented that evidence to Judge O'Grady. We would have loved to have been able to have had an alternative solution to this. We just couldn't make that work.
Sorry, spell that out for me. When you're talking about a security interest, are you saying they wanted a security interest in your property, or they actually wanted the money in hand? In which case, that's not really a bond.
Right. I think they either wanted money in hand or they wanted security interest that we couldn't grant because Northstar doesn't directly own any of the properties. It owns them with equity investors, and it doesn't have the unilateral right to grant liens to third parties. So it couldn't grant outright security interests in order to secure a bond in that nature. Your Honors, my time is up. I'm happy to address any questions. But
I just want to be sure you've fully answered Judge Rushing's question. Judge Rushing?
Yes, thank you.
Okay. I don't have any questions. Judge Floyd? No.
No.
We're happy to hear from from Amazon now. Thank you.
Good afternoon, Your Honor. May it please the court. Elizabeth Pepez Gibson Dunn for the Amazon plaintiffs. I'm going to focus on the questions I think the court raised, many of which are addressed in our briefs, but I think I can hope to put some finer point on them. But I want to begin with a critical point of agreement. Mr. Calhoun, all of his arguments support the provision on appeal. We agree that the preliminary asset relief here must balance the irreparable harm of asset dissipation against the danger, what Hughes called the danger of a mistake about their client's liability. There is no such danger here. The order protects claims the district court found likely to succeed based on evidence almost never seen in a civil complaint. FBI warrants, bank records, kickback proof from the defendants, whistleblowers, criminal conspirators. That's really critical because a preliminary injunction depends first and foremost on likelihood of success. Here, that's not close, it's overwhelming, and it applies to all of the claims in our complaint. I want to go, Your Honor, subject to the court's questions, to Mr. Calhoun's arguments on fraudulent
Counsel,
inducement
excuse
and
me a
RICO.
minute. Can you just talk a tad louder, or maybe your microphone a little louder or something?
I'm sorry, is that better, Your Honor?
Yes, it is. Thank you.
I'm sorry. I'd like to go, subject to the court's questions, directly to Mr. Calhoun's arguments on fraudulent inducement and RICO. Those are separate bases for our claims in the case. The same likelihood of success, the extraordinary record here, supports all of them. But what really matters for the injunction is the unjust enrichment and equitable claims. That is Raman Oncology.
What is your strongest state law equitable claim? What's the strongest one that would get you to your 21 million?
Well, we have several, Your Honor. We think the strongest is unjust enrichment with the disgorgement remedy available under Rule 64, Virginia law. I want to make a point about this because the defendants today and in their reply misstate the record on this in a way that is very important. They say in their brief that we have changed course and that we did not make this argument when the injunction was entered. That is incorrect. I would refer the court to Appendix 517 and 518. This is at the hearing before the district court where we said, and I'm quoting here, the first claim we would highlight because it is uncontested is our claim in equity for unjust enrichment at paragraphs 196 to 200 of our verified complaint. The defendants did not oppose or otherwise take issue with our likelihood of success on that claim, which is incredibly important because under the Fourth Circuit's decision in Raman Oncology, that alone entitles us to the preliminary injunction. That was May 18th, Your Honor. Their brief does not acknowledge that. We have never changed course. And the fraud that underlies that unjust enrichment claim is grounded in Rahman itself. If you look at Rahman, page 497, it defines equitable property as monies obtained by fraud and assets purchased with the proceeds of a fraud. There is no question here, and the district court found, and we're here on an abuse of discretion review, that we had an overwhelming likelihood of success on the record showing that they obtained all of their business with us by fraud, and specifically by paying bribes and kickbacks to corrupt insiders at our company. That is clear on the record. I can tell the court about it, but it might be easier, and if the court is inclined to see the appendix, I can show you. If you look at the appendix, we did not, as the defendants say, put all of these claims on a contract. Before the contracts were executed, these defendants came to our company and asked to do business with us through an RFP process. The record details what happened during this RFP process that shows the fraudulent inducement the court found extraordinary and likely to succeed. If you look at appendix page 1929, in the RFP, before we signed a single contract, these defendants got a template of our RFP that contained a reference to our code of conduct. It says point blank on page 1929 of the appendix that they, as a bidder for our business, agree to abide our code of conduct and not to give consideration, bribes, or anything of value to any insider under any circumstances. They made that representation. They induced us to do business before we ever signed a contract. They absolutely violated that representation, that inducement, when they paid bribes and kickbacks to our former corrupt managers, their co-conspirators, and this is documented chapter and verse in our record. They're here on an abuse of discretion. They cannot come close to showing abuse on the likelihood of success standard. The other thing I'd point out, which is really extraordinary, is that the inducement was not only pre-contract where they agreed to abide our code of conduct, that's at appendix 1929, but if you look at appendix 2102 and 2104, you will see there in the record the copy of the lease that their CEO actually signed. You'll see his name on page 2104. 2 pages prior, it's the same anti-bribery provision, the same acknowledgement of our code of conduct. There's no question there was a fraudulent inducement of every single deal that they did with our company in this case, and that record amply supports the injunction under Rahman Oncology and its definition of equitable property.
Counsel, I think that I understood your colleague on the other side talking about disgorgement isn't an appropriate remedy because after all, this money is subsequently passed on to others. Maybe you can address that.
Of course, Your Honor, I'm glad you asked. Thank you. A couple of points on that. Disgorgement is absolutely available as the traditional equitable remedy on the claims in our complaint, which are for unjust enrichment and constructive trust. The point about indirect payment is actually incorrect. This court in the federal insurance case, and I believe that was in 2001, it's in our brief, I think at page 36 or 37, says point blank, it is absolutely appropriate to disgorge where there's been an indirect payment channel. That's settled equity law. It's the same problem they run into under the Virginia Supreme Court case Davis in 2020 that says you can have an unjust enrichment claim alongside damages and contract claims. That's normal. We get to elect our remedy. Now, why is that fair? Why is that equitable? Equity and the disgorgement remedy targets their unjust gains. The US Supreme Court in the Liu case recently, for example, said an unjust gain or an unjust enrichment is anything the defendant got as a result of their fraud. Here, their fraud and bribes, that was not a legitimate part of our deal. That is the only thing the injunction focuses like a laser on setting aside. These defendants on the record claim over $60 million on our deals. The only thing the injunction sets aside, and I want to be really clear about what the 21.5 million represents. 5 million of it is money that they admit in their opening brief at page 21, they took from unjust gains on a land sale to us that we paid for and was procured by fraud and bribes. Their co-conspirators are cooperating with the US attorney. We have letters in the records saying that's the record on that sale. Undisputed, so the 5 million, clear. Now what about the 16.25? They want to lump that in. There is unrebutted record evidence that the 16.25 million, the rest of the money in this appeal, represents specific unjust gains that they procured by fraud and bribes on 3 of our lease deals. The record on this is really robust, and I'd like to talk about it. If you look on page 7 of our brief, their brief keeps talking about a pure escrow to Judge Rushing's question. We went out of our way, as did the district judge, to say that we would entertain a bond option or some combination. We worked with them for weeks, even after the PI was entered, to try to make some accommodation. But going back to the 16.25 million, if you look at page 7 of our brief and record at 619 to 20, that money is based on a very specific set of 3 sums: 4.15 million, 8.5 million, and 3.6 million that the defendants had earmarked as a kickback and bribe fund on 3 of our deals. We recovered the evidence of those numbers from our corrupt manager's laptop recycle bin as part of the investigation alongside the government's investigation in this case. They have never once rebutted that number. And again, we're up here on an abuse of discretion review. The reason we focus like a laser on that number, and we know under Group O we are shooting for a corner pocket on this injunction, on this record we make that shot. We have the recovered file showing that these defendants had that money from our deals. They've never shown they didn't get it. They've never rebutted it. And it could only be an unjust gain because it was earmarked to pay kickbacks. There's no world in which a kickback is appropriate or just or justified. We focused only on that piece. They've never rebutted it. And Judge Motz, to your question, the only thing they've done is play word games with the law and record. Unjust enrichment, by its terms, is any gain that's not legitimate, and it doesn't matter if you pass it along. If that were the case, you could reward dissipation and laundering. This is the Judge Easterbrook quote in our brief. It goes back to Learned Hand, and it's the principle this court applied in the Raman Oncology case. If you obtain proceeds or gains by fraud unjustly, you cannot avoid a disgorgement, an equitable remedy, simply by paying them out in a bribe or using them to fund your next illicit deal. The law has never recognized that, and that is why the law is crystal clear. There is no tracing requirement in civil equity, particularly at the preliminary injunction stage. Why? First of all, common sense. At the pleading stage, which is where we are now, and again, we have evidence in this record you almost never see in a Rule 8 complaint with the FBI warrants and the probable cause. But at the pleading stage, the defendants are in the best position to know what they did with the money. We don't have discovery. So you set aside and reserve a conservative amount that represents an unjust gain that the record here ties tightly and on an unrebutted file to money that they took by fraud on at least 3 of these leases. That's crystal clear. There's no tracing requirement. We have case law in our brief from the Second Circuit that said that is so well established at the civil PI stage, the Second Circuit disposes of it in summary orders. Virginia law has said the same thing. We have case law in the brief that says there's no tracing, indirect is fine, because what we're focused on is an unjust gain.
Ms. Pepez, you haven't mentioned RICO at all in your argument. My question to you is it's the same to your colleague. Do you believe you can maintain a private civil RICO action and obtain equitable relief?
Your Honor, I say yes, we do, but to be crystal clear on the record, we don't need it here because we have an independent unjust enrichment claim under state law. But to answer your question, we do believe that's correct. We have 2 circuit cases and the plain text of the statute on our side. This is the section 1964A of the RICO statute. Both the 2nd and 7th circuits have recently held that in a private RICO action like this one, particularly where the district court has held this kind of likelihood of success, 1964A permits both divestment as an express statutory remedy, which encompasses the kind of divestiture or disgorgement of the unjust gains we seek in this injunction, and also expressly authorizes injunctive relief to prevent and restrain ongoing violations. These defendants have been taking the unjust gains from one lease deal in this case and reinvesting it in the RICO scheme. The district judge found likelihood of success on the merits on that record. So under both the divestment and prevent and restrain prongs of 1964A's plain text and the 2nd and 7th circuit decisions, Your Honor, respectfully, Judge Floyd, we would say yes, we can get this injunction under RICO, but we don't need it because we have the independent unjust enrichment and other state law equitable claims in this case that seek literally exactly the same claims and relief in Raman Oncology. I want to make clear on that too, that's Appendix 62 in our original complaint had those claims on a standalone basis. You'll also see them in the first amended complaint at Appendix 1741 to 44. Nothing to do with RICO, separate claim. We get to elect the relief in unjust enrichment. RICO also supports it, and the same factual record cuts across the board on likelihood of success.
Ms. Pepez, this is Judge Rushing. Just to be clear on the RICO, even if you claim that you might be entitled to injunctive relief at a final judgment, do you claim that you could get preliminary relief under RICO? That seems to cut against Section B or subsection B.
You know, it's interesting, Your Honor. You mean the Attorney General provision? I think that's
right.
You know,
even the courts that you talk about who went with your reading of the statute say that preliminary relief is only for the Attorney General.
Well, I guess that's one way to read B. I don't know that it's the only or the right way to read subsection B of the statute.
But no court has read it your way, right?
As far as I know, Your Honor, but I don't know that they've had occasion to either. And frankly, in this case, we don't as well, right? Because we pled under Raman Oncology, Grupo, and the Supreme Court's Deckert decision, a case for a preliminary injunction based on standalone equitable claims that rest on the same basis as the RICO. So I think, Your Honor, respectfully, we could argue the textual basis for that, but it's certainly not required at all to affirm this case, and in no way part of the abusive discretion calculus that the defendants are facing in this court. I don't know if the court has further questions. The one thing I wanted to address that came up in my colleague's presentation was the issue of whether we rescinded. I just wanted to be clear on the record, Your Honor. We did indeed, and our joint venture partner did indeed rescind all of the contracts with these defendants. You'll see evidence of that at Appendix 2439, and generally in Volume 5 of the appendix, where we reproduced a host of correspondence terminating and rescinding their agreements as part of these lease ventures and it states in the record that the reason was fraud and willful misconduct, both in the procurement of the deals and their role in the joint venture, as well as their administration on the properties. I guess, and the last thing I would address that the court asked about, and Judge Rushing, I think you were focused on this rightly, and I just want to stress this. The injunction before this court is not only based on this extraordinary record you almost never see in a civil case because of the parallel criminal conduct, but it's even more narrowly tailored than the preliminary injunction for the exact same equitable relief that this court approved in Raman Oncology. And the reason is the bond. We bent over backwards. We talked about this at the May 18 hearing with these defendants. They don't have a right to these funds at all. When you procure money by fraud, this is what Judge Easterbrook said in Quinn versus SEC in our brief. You know, a thief can't say, I have a right to hold the loot to buy a great defense, and a criminal cannot retain unjust proceeds to try to continue an enterprise. They have no right to the money at issue in this injunction at all. Nonetheless, he heard and balanced, the district judge carefully balanced their claims of purported difficulty and frankly, as Judge Rushing pointed out, liquidity. And we came up with and endorsed the bond auction to address that. Judge Grady actually modified the injunction at their request to allow that. And we have detailed in the appendix, including in our show cause brief, chapter and verse, that we reached out, we asked them what we could do to accommodate, they strung us along, they haven't posted a penny. And I wouldn't normally go outside the record here, Your Honor, but since Mr. Calhoun did, I just want to say, since this injunction closed, the record is extraordinary. And on January 8th of this year, just 2.5 weeks ago, they admitted that they have dissipated $82.5 million worth of their assets. I have that in an interrogatory response that the district court ordered because they wouldn't tell us why they couldn't do a bond, and they never proved why they couldn't satisfy the injunction. So respectfully, Your Honor, we've done everything we could to try to balance this. The court should affirm.
Thank you very much. Sir, do you have any rebuttal?
Yes, Your Honor, thank you. The last statement is frankly false. It's why the court doesn't ordinarily go out of the record. The company has been forced to move out of some of its real estate positions. It hasn't dissipated anything. I would specifically like to talk about the $21.25 million that my colleague tried to walk the court through a little bit and said that this is the money that's subject to this injunction. And she pointed you to page 282 or 283 of the appendix, which is the spreadsheet that they allegedly found in the trash bin. If you look at that, it's quite an interesting document. There are 6 transactions listed there. The first 3 rows are the North Star transactions. Why there are more than there, why the other 3 are there, we don't know. Sort of undercuts their theory that we're involved in a conspiracy. But in any case, if you look at that transaction, there are 4 columns. They have based their injunction based on the totals of the first 3 rows. If you look at the bottom of that, there's a share. So under any circumstance, the 3 rows, the totals of that would be the total amounts theoretically that would be paid on these, and the share would be the alleged amount that would be payable to their employees, I presume, based on what they're saying. But even on the face of the document, a number of the columns pertain to sale or land rebates, which are actions that have never taken place and certainly never been paid. There is simply no basis for 16.25 as a factual matter having been paid to my clients. It didn't happen, has not happened. Amazon didn't pay these funds. They didn't come forward and say, here's the checks we paid these funds. Those funds don't exist. They were never paid to my clients. The fact that the spreadsheet lists numbers doesn't create a fund out of thin air, which is what they're asking for.
Mr. Calhoun, as to the $5 million, can't that be traced to the direct purchase enterprise and it's in existence and a constructive trust could be imposed?
My clients were paid $5 million in connection with a settlement under a negotiated settlement with 2 of its former employees pursuant to a mediation with a former Colorado judge. interesting that $5 million, the claim underlying that is that those former employees did a deal with Amazon and caused it to pay an increased price. What's interesting about that, if you look at the underlying contract, which is in the record, the increased price on that was in the contract itself. It was apparent. Amazon can't claim it was misled into paying more than some market price for the property because it was right there in the contract. And they signed it. There's no argument that they were misled into buying that property at an inflated price because if they looked at the contract, they knew the allegation was that it was a flip transaction, but they knew the buy and sell prices of the flip because it was in the contract on its face. My clients brought a claim against her, alleged that their former employees had usurped that opportunity. They should have brought it to the company and said, hey, we've got a new Amazon deal. That they did it on their own account. But more to the point, that money was spent in large part. There's not a simple.
And you put all of this argument in front of the district judge, right?
Maybe not as well articulated, but it was put in front of the judge, yes.
And it's in the briefs before us, because I don't remember exactly this articulation.
The same is true of the unjust enrichment claim. In their original moving papers, they didn't argue for the equitable, their complaint did not seek equitable relief on the unjust enrichment claim. They raised that at the hearing on the preliminary injunction. So we argued that at the hearing. It's simply not true that we didn't oppose it. The complaint originally didn't ask for equitable relief in connection with that.
Sir, I don't think I was very clear. Remember, you went through and said that these aren't really things. You went through the items and said that they were demonstrating the injunction, and you made that argument to the district judge, right?
We did make that argument to the district judge.
And you made it here in your briefs.
Correct.
Okay.
I also want to point out what they said that they've rescinded these contracts. They're not seeking rescission in the case. What they did is reform the contracts. They didn't return the property and say, give us our money back. They said, they went to our equity partner and said, we want North Star out of these transactions. So they reformed those contracts to remove the North Star affiliates from the transactions. They're keeping the property. They didn't rescind these transactions. I want to make that very clear. And that's pertinent to the unjust enrichment, because if you look at the value given to each side in an unjust enrichment claim. My time's up, Your Honor, but we respectfully request that you reverse the district court and vacate this injunction.
Thank you very much. We're happy to hear argument in our next case, France versus France Com, number 201016.
Thank you, Your Honor. My name is John Green. I am the counsel for the defendants in this case, the French Republic, its Ministry for Europe and Foreign Affairs, as well as its official tourism agency, Atout France. Your Honors, this case is the result of the plaintiff's dissatisfaction with the result of a years-long litigation in France. Many years ago, the plaintiff brought an action in France to enforce its trademark rights in France. And the government of France, seeing this, intervened to assert its sovereign rights in its identity as the country of France. French district court in Paris agreed with the government's sovereign assertion of rights.
Counsel, excuse me, can I interrupt you just a second?
Of course.
I thought the original action was by the defendants here against some third party that is not at issue here, right? And your government, the French government, intervened. Is that correct? The French government didn't bring this claim against him.
The French government intervened in litigation that I think was brought by the plaintiff, France.com, against a third party defendant in France.
Yes.
That's right, Your Honor.
So the defendant voluntarily subjected himself to the French court.
Yes,
correct?
That's correct. And
Right.
and in the French court, the issue of whether France could intervene was litigated and decided. It's important, I think, for this court to know that this case is still going on in France. The French Supreme Court has the matter under advisement, and a decision is expected later this year.
Well, how long has it been considering it? It sounds like it's been considering it a long time.
Well, I don't know the exact number, but I think it has been at least a year and a half.
Do you know when the appellate court issued its opinion? I can find it. I mean, I'm sure you've told us.
Well, the appellate court decision is what began the series of events that led to this case. The government of France sent the French appellate decision to web.com, which was at the time was the registrar of the domain name at issue, pursuant to the registration agreement with the plaintiff. Web.com exercised its discretion to act after it received a court order, which awarded the website to France. That is the act that ended up resulting in France having control over the website and the plaintiff losing its control.
Sir, can we say that this lawsuit was based on the French state's assertion of trademark rights?
Respectfully, Your Honor, I don't think so. I think the French decision and French action was based on France's assertion of its sovereign identity rights. It is not something that a private plaintiff could have done in the way that a private plaintiff might bring a trademark case.
But that's not so key to your argument here. What's key to your argument, I think, is that this action results from the decision of the French court.
Yes, and that gets at the key issue that the Supreme Court teaches has to be resolved in any FSIA exemption determination, and that is, what is the actual injury? What is the act that actually injured the plaintiff? What is the gravamen of the case? That is the term used in the Sachs decision. And here we say the gravamen in this case was the alleged taking, as the plaintiff puts it, of the domain name. It was the transfer, and from that flows all of the alleged injuries that the plaintiff discusses in its complaint. If you accept, sorry, go ahead.
No, I was just going to ask you, so that this case seems to me to be a real intersection of comedy concerns and this immunity. Have you ever seen another one like this?
I have not seen another one like this, no, Your Honor. I know the Supreme Court is considering the intersection of the FSIA and comedy right now in the Germany versus Phillips and the Hungary versus Simon cases, which are pending.
And are there foreign state court decisions that provide the basis for the claims there as you are here?
I'm sorry, Your Honor, I did not quite understand you.
Well, maybe because I wasn't clear. It seems to me that the gist of what you're saying here is that a French court's decision provides the gravamen, if you will, the basis, the harm that is claimed by the plaintiff here.
Yes, yes, I agree with that.
Do those cases involve that same kind of setup? In other words, a foreign court's judgment being an issue?
I do not recall that we found any case in the FSIA area that has that set of facts. I would say that set of facts means this is a very ripe case for the application of international comedy. This issue, the who should own France.com, is the issue that is being litigated in France. And if you accept, as we do, that international comedy is a separate ground for a federal court here to decline to exercise jurisdiction, even if it has jurisdiction under the FSIA, we think this court, that comedy provides a separate basis for this court to dismiss this claim with prejudice.
Can I ask you one other question about that? So you told us that the French case was still proceeding.
Yes.
Does that mean that the plaintiffs here have appealed there?
That's my understanding, yes.
Okay, thank you.
Judge Motz, we lost Mr. Barlow.
Oh dear.
I need to try to get him back in, so stand by, please.
Sure, sorry.
Barlow back?
Sorry, Your Honors, I'm having to join on my phone. Something has gone wrong with our system here.
Mr. Barlow, can you tell us how long you've been off? Remember what was going on when you left?
I would imagine that it feels like a longer time to me than it does to you, so I would guess just maybe 2 minutes.
Oh, and Mike, is that what you would believe is true too? Mike Dean?
Yes, ma'am. I think that was about it. About 2 minutes.
Okay. Maybe I can ask you, Mr. Rosen, to sort of recap the last 2 minutes. Okay.
Sure, Your Honor. So I think Your Honor had asked a question about whether the court decision in France was the gravamen of the action, and I agreed with that proposition.
And then I think there was discussion about where that action was, what was going on.
Yes, Your Honor. So that action is currently pending in France. It is under review by the Supreme Court of France. My client tells me that a decision is expected sometime by the summer or the fall, and that, to my knowledge, it is the plaintiff or his representatives that appeal that decision from the intermediate court in Paris to the Supreme Court.
Mr. Graham, let me ask you 2 questions. One, shouldn't the district court have resolved the sovereign immunity issue early on? And then the second question is, how does the territoriality of a trademark law affect our decision with respect to the French court's decision on French trademark law?
Those are good questions. So turning to the second question, it is true that the plaintiff here asserts a U.S. trademark in France.com. For purposes of the sovereign immunity question, we need to look at what the gravamen of the action is. And that we submit based on the complaint and the pleadings is the alleged taking of the domain name, which resulted in France later using the domain name to direct internet traffic to its pre-existing France tourism website at france.fr. Judge Floyd, could you repeat your first question? I'm afraid I've lost it.
Should the district court have early on resolved the issue of sovereign immunity?
Yes, Your Honor. We believe that it should have. We believe the cases both in this circuit and elsewhere teach that it's the obligation of the district court to issue a detailed analysis because the purpose of the FSIA is to protect the sovereign not just from the consequences of litigation, but also participation in the litigation. The lower court here, we filed a motion to dismiss on 2 grounds initially, the FSIA ground as well as Rule 30b-6 on the ground the complaint did not meet the pleading standards. The judge denied the FSIA motion without discussion, but granted the Rule 30b-6 motion. And this is important because here the plaintiff has had 2 opportunities to plead an exception to the FSIA. It is, of course, the plaintiff's burden to do that, and we think that the plaintiff has not done that.
Can I go back to your answer to the Judge Floyd's other question where you said, I thought that the gravamen of the complaint, the gravamen of the suit here is something other than the French judicial action, the French judicial decision.
Oh,
so,
no, that wasn't what I meant to say. What I'm saying is that the gravamen, for purposes of FSIA, is the alleged taking of this domain name, and that the trademark and other claims basically flow from the later use of the property that was allegedly taken, the domain name.
But when you say taking of the domain name, do you mean decision by the French court? Is that what you mean?
I mean the decision by the French court awarding the domain name to France And then France sending the decision to web.com, the ultimate technical act which caused the transfer was something that web.com did as it was permitted to do.
Okay.
So another point I'd like to make is if you accept that the gravamen is the alleged taking of the domain name, and I urge the court to review the complaint and see how all the alleged harms flow from this act they say was wrongfully decided by the French court, then all the allegations with respect to what is being done on the French tourism website, whether or not that website or France receives any fees for advertising that may be on the website is all not relevant, because the Supreme Court, as well as the Second Circuit in Garb, taught that it's important to separate out any subsequent commercial use of the allegedly taken property from the act of taking, which is the gravamen of the lawsuit. I'd also like to make a point about the contacts, or lack of contacts rather, between the operation of the website in France and the United States. The plaintiff appears to be arguing that there is sufficient substantial contacts, as the FSA requires under the commercial activity exception, in order to sustain jurisdiction here. And we submit that on the pleadings that is simply not true. The website france.fr is managed in France. The web domain name france.com is registered in France. That website is a passive website, and that means that it would not serve to meet the minimum contact standards if this were a straightforward trademark case.
Well, let me ask you this: what should have gone into the comity analysis? Territoriality?
Well, I think that's certainly the starting point on this. I think the comity analysis should look at the importance of the issues to the foreign sovereign and whether a U.S. court is the right venue for those issues. Here, the Republic of France is asserting its sovereign rights to its identity in its own courts. And I want to draw the court's attention to the BAE Systems case, which made the point that comity principles are even more important where a sovereign is asserting its rights in its own courts.
Change your mind.
Turning briefly to the expropriation argument, if you accept that the taking of the domain name, the alleged taking, is the gravamen, there are many reasons why this does not constitute expropriation as defined under the FSIA. First, of course, as Judge Motz has pointed out, the act that resulted in the taking is the operation of a French court. That was after years of litigation, and there's no suggestion there was not due process or fair opportunity in that case. That's not a taking. There's no violation of international law here. The plaintiff makes some points, tries to argue that the result of the French court would not have been reached here in the U.S., but that is not international law. And I think it actually highlights the principle that in international comity consideration, where we're looking at a long-established prior litigation that's been going on for some time, the U.S. court should not take their time to decide that issue when it's already being decided. The exact same issue is being decided elsewhere.
I have one more question for you.
Of course.
Do you think that France.com has sufficiently alleged the commercial activity exception to SIA?
We do not. We do not
And
think
why?
they have.
And why not?
Because you have to start with the gravamen of the action, and that the gravamen, which is what you use to do this analysis, is the alleged taking of the domain name. That was not commercial activity. When a court in France makes a ruling, that's not commercial. When the government sends that ruling to web.com, that's not commercial either. That's not what the Congress intended when it wrote commercial activity. And even if you think that the operation of the website in France, which allegedly receives traffic when people type in france.com in their browser bar, that website has no substantial contacts with the United States, and that is one of the four, one of the elements required in order to have commercial activity. I see my time is up.
You probably reserved some time for rebuttal.
I did.
We'll hear from your colleague now.
Yes, Your Honors, and I'm trying to log in on my computer right now. I don't know if that is possible. I have the Fourth Circuit oral argument screen open, but if not, I'll just go with the phone.
We can see you very well.
We can. Well, here, it's coming up now. Thank you.
Great. We can see you, counsel. Can you see us?
Yes, sure can, Your Honor. There, I believe that's up. Can everybody hear me all right?
I can.
Yeah.
I think we can.
Well, good afternoon, Your Honors. I'm Ben Barlow. I'm representing the France.com, the appellee, and may it please the court. Your Honors, with all due respect, this is not a case about a French court judgment. And this is not a case about the act of sending a letter. France is sending a letter to web.com. That's not what this case is about. The French court order that my colleague has spent their argument talking about today didn't order anyone to do anything other than my client. It ordered my client to transfer his domain name or face a fine. It didn't order web.com to do anything. It didn't give appellants any rights to take any action. It was not a self-executing order that could just be presented in the United States with any sort of judicial review and expect that somebody grant deference or grant comity to the decision. This case is about trademark infringement.
Well, but can I just ask you about this order for a minute? It was an order by a French court to which your client subjected itself to the court voluntarily. You weren't dragged in. And so there it stands. Now, if we issue an opinion in a case, there may not be any injunction issue with it, but we expect people to, particularly people that have come in and asked for our opinion on something, to honor the judgment. And we expect the general public to also honor the judgment unless they appeal it. And of course, you have a perfect right to appeal, and as I understand it, you have it.
And Judge Motz, I would agree with you in the normal situation. If this court order had been taken somewhere in France, I would expect French people to give deference to it as a statement of courts in their jurisdiction. However, we have principles of domesticating and recognizing foreign judgments in the United States. And France took every action possible to avoid any judicial scrutiny of this French court order. There was no judicial review of this court order to determine whether it offended the public policy of the United States. It's explicitly contrary to our trademark law in the United States. This was the French court litigation that the French government intervened in was litigation over it was a trademark litigation case, trademark infringement case that my client had filed in France. You'll see in the joint appendix that the decision of a two France and appellants to intervene in that litigation was for the specific purpose to get the domain name. This wasn't because they had an interest in the underlying trademark litigation. They had the intent and purpose of just getting this trade name, because when you review their own meeting minutes, rendezvous in France was too hard for people to type into their systems. So even though they have
Mr. Barlow, sorry, this is Judge Rushing on the phone. Hi.
Yes, Your Honor.
you seem to be arguing now, and I think partially in your briefs, about that France didn't go through the proper procedures to domesticate this order. But do you have a cause of action for failure to properly domesticate? Aren't these arguments better lodged against web.com and whatever claim you may have against them?
But Your Honor, as is included in our brief, because litigation against web.com must be commenced in the Middle District of Florida, there is currently activity ongoing, and I'm not involved in that part of the action where we're negotiating things with web.com. But this case is about the appellants infringing my client's trademark. The order didn't.
No, this case is about. I think this case is about the French court awarding your client's trademark to France, but they're not infringing it. The French court gave them the right to take it.
With all due respect, Judge Rushing, this case is the appellants infringing on the trademark, because while the order said that my client had to voluntarily transfer their domain name, my client has a long-standing trademark in the United States of France.com. That's its trademark. When the appellants use the domain name France.com to redirect internet traffic to their own tourism promotion sites, they're infringing on my client's trademark, my client's United States trademark. When they use a domain name that is the same as my client's long-standing U.S. trademark, a trademark that is perfectly appropriate, as the Booking.com decision reaffirms, when they do that, they're committing cyber squatting. We have a count for cyber squatting. Every count we have in our complaint does not depend on a French court decision or on a letter. That is not the gravamen of the suit. The gravamen of the suit for 4 of the counts is how France is currently using my client's trademark to promote their own interests.
Can you point me to the allegations in your complaint that establish a violation of international law?
The violation of I'm not sure, Judge Rushing. Can you clarify? Or
well, for the expropriation exception, for the takings exception, you have to have established that it was taken in violation of an international law. So I'm having trouble finding that that you've established a violation of international law.
Your Honor, case law says that a taking without just compensation is in violation of international law. That when a taking occurs and compensation is not provided for the item took, that deprivation of property without compensation is in violation of international law. That's included in our brief.
Pursuant to another country's court order?
What this was
Certainly not.
Well, this was not the French court ordering the transfer. France didn't act as a sovereign. France didn't act as a sovereign in attempting to get the transfer of the domain name. They acted as a private party. It's private parties that send a letter that sort of misrepresents what an order states, stating that an order is enforceable and leading web.com to believe that an order is enforceable in the United States and is binding upon them. That's how a private party acts.
Well, excuse me, counsel, the French court isn't a private party. We're all in agreement on that, right?
No, Your Honor. I'm not
The French court
disagreeing.
is a private party?
No, I'm agreeing with you, Your Honor. There's no dispute.
Okay, the French court isn't a private party. And France, the country, used the decision of the French court, right? And the decision of the French court is what caused you damage.
Your Honor, with all due respect, I don't believe that is so.
Okay.
That let's say, for argument's sake, and I disagree that the French court decision is what effectuated the transfer here, because
it made the transfer possible. There would have been no possibility of the transfer without the decision of the French court. So
That is
we
indeed,
agree on that, right?
that is indeed the tool that appellants used to get the transfer. I would suggest that they could just send a same sort of pressuring letter to web.com, but for sake of argument, Your Honor, that happened and the domain had been transferred to France. France then appellants had to take the affirmative step to use that domain name improperly and infringe on the trademark. That it's their use of the domain name that's infringing on my client's trademark. That there's no cyber squatting, and there's no if they take the domain name, if they get the French court, what they originally asked the French court to do is either award them the domain name or let my client keep the domain name and simply say they couldn't operate their business with that domain anymore. If they had gotten the domain name and canceled it because they didn't want to have my client competing with them in France, that wouldn't have been necessarily infringing on my client's trademark. What infringes on my client's trademark? What commits cyber squatting? What is the grounds for the reverse domain name hijacking is the way that they utilize the domain name in redirecting to their tourism promotion site.
Okay, maybe I think I understand your argument now, which, you know, we all like to understand each other. But so maybe you can give me the case that you think is closest on this, because I spent last night reading some Supreme Court cases and some Second Circuit cases, and I couldn't, it seemed to me that they were looking for the triggering event, the thing that was, as you say, that caused your harm. You didn't have this, well, this happened, but you had to go, they didn't break it down in steps in the way that you would like to do here. So what's the best authority I can look at to see an example of what you're talking about?
Though it's not binding on this court, the Second Circuit's recent decision in Pablo Starr is close to on point. The Second Circuit in that decision didn't focus on how the Welsh government got those pictures of the Dylan Thomas poems. They didn't ask whether it was an intern that had done that, or whether there was a right click and paste, or whether somebody took a photo in a studio of those items. They weren't concerned with how the Welsh government got those photos. What they were concerned with was what the Welsh government did with those photos, how the Welsh government infringed on the intellectual property.
But of course, they didn't have the Welsh government getting the photos in the same way that the French government got this website, correct?
Well, even if that, Your Honor, I don't want to argue with your position. That is right. There's no Welsh government decision giving anyone any rights in any photos. But the rights under United States trademark law, those things that Justice Ginsburg says in the Booking.com decision are valuable property rights that are conferred when you have a trademark. Those valuable property rights in this country that have trademark protections, France doesn't get to say that those trademark protections can be violated in the United States. A French court doesn't get to say that. If a French court believes that that is what should happen, that my client should not have its trademark rights in the United States, then the way a French court or the French government would act as a sovereign is they would get our government to recognize that position. They would get our courts to recognize that position. When you look at both Pablo Starr and Pablo Starr's looking at Justice Scalia's decision in Weltover and looking at Justice Souter's decision in Nelson, that you're looking at what the actual act was that gave rise to the claim. The claim is trademark infringement. The claim is cyber squatting. The claim is federal unfair competition. Those claims have to do with how the trademark is being used, how the domain is being used and misused. It doesn't have to do with how France managed to get the domain name in the first place.
But counsel, it seemed to me, I looked at this pretty carefully because we do have a bunch of claims, and the Supreme Court Second Circuit haven't gone down the claims one by one. They've said the gravamen of the complaint, you look at the source of what caused your harm. And that's where I'm kind of stuck here.
Look, trademark infringement just as the case would be in Pablo Star. Your Honor, if I take someone's copyrighted information and I just keep it in my desk drawer, I haven't infringed on their copyrights. Someone might be able to get me for theft of property, in this case, expropriation. Somebody might be able to get me on another claim on how I got the property. But an intellectual property infringement suit depends on how the intellectual property is used or misused. There's no question that, like I said before, the Second Circuit is not looking at how those pictures of the poems were taken or how they were received, regardless of whether they were received by a court order or whether they were received by somebody simply snapping them on their phone in an art gallery. What the Second Circuit was concerned with was whether the sovereign was doing something that, if done by a private party, would subject them to liability. And there's no argument here that if a private party did just what the appellants have done in this case, that they would be subjecting themselves to suit for.
Mr. Barlow,
Judge Floyd?
Same question that I asked your colleague. Shouldn't the district court have considered the sovereign immunity claim and have given you a chance to say we fall within the commercial activity exception of SSIA? I mean, isn't that what should happen here?
Judge Floyd, I think that's right, and I think that's what's happening here. Judge O'Grady, or the district court, early on saw our allegations in our complaint. He heard oral argument, and in what this court says in Base Metal and Lewis, where it commits the question of whether to order discovery and the scope of discovery to the sound discretion of the trial court, the Eastern District, in its discretion, said, I need some discovery here before I can make this decision.
Well, did he address sovereign immunity or just look at your allegations?
No, yeah, absolutely, Your Honor. In his order, in the court's order, when we discussed these issues at our hearing a long time ago before the virus, that when we discussed those issues, the court said these issues of sovereign immunity are best resolved later in this process. Now, we understand there is no disagreement. I don't pretend that there's no authority out there saying that these questions of sovereign immunity are important and need to be raised as early in litigation as possible. But that's clearly what the court says. But early in litigation is a broad spectrum. That early in litigation doesn't mean before either party has an opportunity to develop a factual record, but that's not quite right either. At this stage of litigation, it would mean that we make those determinations only when the sovereign has been allowed to develop their own facts and present their own self-serving affidavits. And frankly, this court, I know that you and Judge Motz are far more familiar with the KBR cases and the Kearns case than I am, but those cases stand for the proposition that there are a number of situations where we need some amount of discovery to fully inform that decision by the trial court. The trial court shouldn't make these decisions with blinders on.
So what you would want is to have it sent back and have us order the district court to provide for a limited jurisdictional discovery.
I believe there should be jurisdictional discovery, just as in the Kearns case, though, in KBR. I believe that we're facing some situations here where the same facts that go towards jurisdictional immunity are closely intertwined with the facts that surround the merits of this decision. And so I believe that questions about, for instance, questions about how this taking occurred, because this taking didn't just involve web.com doing something. If you look at the Global Santa Fe case, that there's a good description on how transfers and cancellations of internet domains occur. Well, this required France to do.
In the scheme of things, I think you would like to have happen is get limited jurisdictional discovery, and upon completion of that, then the district court would be in a better position to rule on sovereign immunity.
Absolutely, Your Honor, because the district court, we've never acted like the decision on sovereign immunity has been made. We've always taken the position that all the district court ordered below is that we have discovery so that facts can be developed so that we can address the issue of sovereign immunity. The issue of sovereign immunity doesn't have to wait until a summary judgment motion, even though the court below said that that would be better raised at the summary judgment stage. We just believe that there should be some factual discovery. And Your Honors, a very important point that I raised in my brief that would go towards that that jurisdictional discovery is this issue that Mr. Grimm, my colleague, calls a novel theory, and it has to do with negative commercial activity. Because if we have jurisdictional discovery, and I ask discovery around the intents and purposes of what France did during this, we're going to get discovery objections that say that's not relevant. All we look at is the current commercial activity that someone is taking. No other court, no other circuit court has staked out a position on this, and it seems like a self-evident to me, but my opinion is worth only that. A decisions and actions that are taken to destroy a commercial business, or actions that are taken with the knowledge or reasonable belief that a destruction of a business will occur, are every bit as commercial as any other commercial activity that you'll take. And if this court is going to send the decision down for jurisdictional discovery, then I believe it's important to say that negative commercial activity, the act of taking negative effects on an American business, are just as commercial as any other commercial activity that you can take.
Did you file a cross appeal? Did you file a cross appeal?
No, Your Honor.
Okay.
We believe the decision below should be affirmed, and I thank the court for its time. But any other questions, I'll be glad to address.
Thank you. Judge Rushing, you have any questions?
No, ma'am.
Counsel?
Thank you, Your Honor. I have 5 minutes just to make a couple of points. First, my colleague ended up sort of arguing his view of the merits. This appeal and this argument is about jurisdiction and whether there is an exception to the FSIA that fits. The Supreme Court teaches, and even in Pablo Starr, this is very clear, you have to figure out what the gravamen of the case is. And Sachs teaches that artful pleading does not get you around this. The plaintiff has made a lot of claims, but if you read those claims and you look at the facts, the conduct that actually injured the plaintiff is the loss of the domain name as a result of the French court decision and web.com's decision. So you don't need to get to what might happen in the future if this were to get anywhere, because they haven't met their obligation to prove an exception under the FSIA.
Because your contention is none of that is commercial activity.
Those two things are not commercial activity, and everything having to do with the website, what France later did with the domain name that it obtained through its sovereign act, its assertion of sovereign rights, is exactly the sort of thing that Garb says doesn't change the gravamen analysis. So Judge Rushing had a good question about whether there were any violations of international law. That relates to whether or not there could be expropriation here. And if this case is anything, if these facts fit into any of these exceptions, the closest is arguably expropriation, but we have many reasons why that doesn't apply. Of course, failure to allege a violation of international law is one of them. The other one I want to bring the court's attention to, and this applies on both of the exceptions, is that there is no substantial, no substantial contacts with the U.S. This is a French website. While it is in English, It is directed to the whole world. There are many people outside the US that speak English. It is a passive website. You cannot buy anything from the website directly. It is not selling anything, and where it does offer goods and services, those goods and services are in France. There is no direct effect in the United States, and this certainly would not qualify for minimum contact, which this court's decision in Girding teaches is less than what's required under the FSIA. With respect to Pablo Starr, that case is a very good example of, I think, both the gravamen analysis and also why there is no jurisdiction here. Jurisdiction was found in Pablo Starr because of the activities of the Welsh government in New York with commercial operators. The opposite is true here. My client is doing things in France on the internet there passively. There's no allegations that France has done anything in the United States that might support jurisdiction in this case. With that, I'll rest my argument, unless the court has questions.
What do you want us to do? What relief do you want?
We want you, thank you, Your Honor, I should have concluded. We want you to dismiss this case with prejudice. It does not allege on its face, and this is why the court granted jurisdiction, is that it should decide at an early stage before discovery whether or not there is an arguable basis for jurisdiction. So we think there is no pled basis for jurisdiction. You can consider the submissions, the declarations below. They were unrebutted by the plaintiff, and the law teaches they can be considered at this stage to determine whether there is an exception made. So we believe this court should dismiss with prejudice. We also believe this court can dismiss with prejudice on the international comedy grounds. This case and the question of who should have France.com is going on in France and will go on there for a while. The US court should not consider this and should defer to the sovereign nation of France and its determination of that issue.
Thank you, counsel. We appreciate your argument. I'm sorry about the problems with the internet, but I think we got all together.
Not your fault, Your Honor.
We appreciate your arguments. Usually, I don't know if you know this, but in the Fourth Circuit, we come down and shake hands. We obviously can't do that here, but we are very glad to have you with us. And I guess you're still in New York, right? Counsel?
Yes, Your Honor.
Yeah, and you're in Virginia somewhere?
Yeah, I'm in my little office in Leesburg. So,
we saved you a trip. Anyway.
Well, I was looking forward to the chance to come down to Richmond. That Professor Jones over at the University of Richmond was going to take me out to lunch today.
Well, we always enjoy coming down to Richmond, so we're sorry to miss you too.
Well, stay healthy.
Thank you very much.
Thank you, Your Honors.
We'll go to our next case. Counsel here? Okay, do we have counsel? We're happy to hear argument in Armento versus Asheville Boncombe, number 201100. Good afternoon.
Good afternoon. May it please the court. I'm Claremont Ripley from the North Carolina Justice Center, and I'm here with my colleague Carol Brook on behalf of appellant Gregory Armento. The primary question before you today is whether Mr. Armento was an employee or a volunteer when he performed unpaid labor for the appellee, Asheville Buncombe Community Christian Ministry, or ABCCM, under the North Carolina Wage and Hour Act. According to the Supreme Court in Tony and Susan Alamo Foundation v. Secretary of Labor, the appropriate test for distinguishing between an employee and a volunteer is to look at two factors: whether Mr. Armento worked in contemplation of compensation and whether he volunteered for his own purpose or pleasure or was somehow coerced to volunteer. Pursuant to that test, the Alamo test, Mr. Armento was an employee. However, the trial court did not follow the Alamo precedent. Which legal test or which legal framework applies and the ultimate question regarding employee status are both legal conclusions entitled to de novo review. Now, I'm here to answer your questions, but if I have time, there are three things I'd like to cover in addition to why the Alamo test is correct. First is that when someone is considered an employee, they are entitled to all of the Act's protections unless an exemption applies, and there are no applicable exemptions here. Second is that the primary beneficiary test is not appropriate, but under a proper application of that test, Mr. Armento is an employee. And finally, I'd like to talk about how the relationship between Mr. Armento and ABCCM falls within the purpose and the scope of the Act, and therefore the approach from Steelman v. Hirsch and that analysis is not appropriate either. So turning first to the Alamo Foundation. There, the Supreme Court said that a volunteer is an individual who, without promise or expectation of compensation, but solely for his personal purpose or pleasure, works in activities carried on by other persons, either for their pleasure or profit. The trial court made only one reference to Alamo for the proposition that an individual's understanding as to whether he would be compensated may be relevant in determining their employee or volunteer status. And because the court found that Mr. Armento knew his service hours would be unpaid, it did not do any further analysis of those factors. But in Alamo, the foundation residents that the Supreme Court found to be employees also did not expect to be paid. They, in fact, said they did not want to be paid, and they testified that they had no expectation of receiving a paycheck. However, the Supreme Court said that they were still working in expectation of contemplation because they worked in expectation of receiving room and board from the foundation. The same is true here, and that's supported by, that's in the factual findings from the trial court, that Mr. Armento received free room and board, and that he performed those service hours to continue receiving that free room and board, because if he did not perform them, he could have been kicked out of the shelter where he lived. The trial court also, the other...
Ms. Rippon, let me ask you this question. Do either one of these programs constitute a market-driven exchange of labor for value?
You're asking about, does either Alamo or ABCCM?
No, the programs in this case, are they market-driven?
Once ABCCM decided to run this shelter and hire people to work for it, then it became a business. And I mean, I recognize that it's a nonprofit, but that does not mean that it doesn't have to operate and keep its business running. So, I mean, I know that that ABCCM has brought up this argument that it's not a market-based exchange of labor, but Mr. Armento worked for them for pay. He did not pursue other jobs while he was working for them for pay because he thought he was employed. So I mean, it was an exchange of labor. It was a bargain for exchange of labor. Judge Rushing, I believe you were trying to ask a question as well.
Yes, you said that the record and the findings of the district court supported the idea that this is like Alamo, where the individuals were receiving room and board as their compensation, and that those things would be withheld, and in fact were withheld from people who didn't work sufficient hours. That was not my understanding of reading the district court's findings here, was that in fact people who weren't able to do service hours at this facility still received room and board, and that they weren't working to receive it, that they received that room and board gratuitously, and then part of the rehabilitation is that you perform some sort of service hours either at ACCM or somewhere else.
It's finding of fact, paragraph 13, which is on the appendix on page 799, that I'm primarily referring to, where the trial court said that ABCCM had this 3 strikes policy, and that if residents did not comply with the rules, they could be kicked out, and service hours were one of those rules or one of those requirements. It is true that ABCCM...
But service hours don't have to be at ACCM, right?
Right. Their paperwork does say that they could be elsewhere. But the service hours that Mr. Armento performed were at ABCCM, and that is the only issue that is before the court. I think whether service hours performed elsewhere might be legal is a different issue, and this court doesn't have to decide that.
Well, no, it's not. It's not. We're not deciding the factual question. The reason it's relevant is because it helps us understand whether this was a a requirement that you're working to earn your room and board, or whether this work requirement is related to the rehabilitation rather than to some sort of way to pay for your room at this shelter.
I understand, Your Honor, but there's no exception from the Wage and Hour Act for work that is rehabilitative. And work can be both rehabilitative and employment. Alamo recognized that. That was also, there's a case about Salvation Army, Williams v. Strickland from the 7th Circuit, or the 9th Circuit, excuse me, that also recognizes that work can be both rehabilitative and employment. And it goes back to that issue that if there's an employer-employee relationship, that Mr. Armento is protected, is entitled to the protections unless an exemption applies. There's also no exemption for nonprofits under the Wage and Hour Act. There's not an exemption just because ABCCM was doing good charitable work. Once they entered into this economic relationship with Mr. Armento, they have to comply with the rules. And under Alamo Foundation, Mr. Armento was their employee. There's an important distinction, I think, though, between this case and Alamo Foundation, and that is that Alamo was under the Fair Labor Standards Act, which means the court spent a great deal of time analyzing whether they were engaged in commercial activity, because that's a requirement for the Fair Labor Standards Act to apply. That is not a requirement for the Wage and Hour Act to apply. So all of the emphasis that court put on commercial activity in the application of the act is not useful here in determining whether he is an employee. The other test that is useful is the economic realities factors that this court laid out in Schultz, adopting Supreme Court factors from long ago in US v. Silk. And that test, I think, is very useful when we look at Mr. Armento's actual paid employment, the time that he spent at the front desk working according to a schedule, time that ABCCM considered him an employee, under a supervisor, filled out employment forms. If you look at the economic realities factors, he was clearly an employee during that time period in an employee-employee relationship. And those service hours, those front desk hours, the time he spent working at the front desk as paid employment, was absolutely indistinguishable from his front desk work that was considered service hours. The only difference was whether it was paid or not. And in fact, whether it was paid or not was up to how ABCCM classified it, and they could even reclassify it retroactively. There's a spreadsheet included in the trial court's findings of fact, and a discussion about the operations manager reclassifying some of his hours as service hours or as not service hours afterwards. So the fact that he was already in an economic relationship and economically dependent according to those Schultz factors when he was working at the front desk shows that all of his time working at the front desk should have been considered employment. I'd like to quickly turn to the primary beneficiary test, which the lower court discussed, because that test is not appropriate here for the same reasons I've been saying, that Mr. Armento was compensated. And the Supreme Court said that without a doubt, if someone works in contemplation of compensation, they are covered by the act. If a trainee, works in contemplation of compensation, they're covered by the act. Here, as I've been saying, Mr. Armento did work in contemplation of compensation, both in the form of room and board and also for the actual wages he did receive.
But how do we determine that? By just what the testimony is of your client?
I believe there are facts in the record showing that he was paid $9 an hour. There's actually stipulations that he was paid $9
No, but I'm
per hour.
talking about the question about his compensation, that he's going to be paid for every dollar he works.
Well, I don't think it doesn't have to be that he's going to be paid for every dollar he works.
Well, I thought that's what your whole claim was about, really.
We are asking that he be paid for everything that is considered work under the Wage and Hour Act.
But if he didn't compensate, I thought you also said to us that what we look to is what he compensates, what he believes he's going to be paid for. And that seems to me that can't be the standard.
Right. No, I don't think that is. I was actually saying what he believes he's going to be paid is not as important as what actually happened. And that's what the Alamo court looked at. Those residents did not believe they were going to be paid, but they were still employees because of the compensation that they received for their work. Here, We dispute the finding that Mr. Armento knew he was going to be working for free, but that's immaterial actually, because he was in fact compensated at $9 an hour for some of his time. And for the rest of his time, he was still compensated in the form of room and board. According to the Supreme Court, that's the same as wages. Another way to look.
It's not the same as wages that you can play it off against each other. I mean, we know that. That's forbidden by statute. In other words, you can't say, well, I'm going to give you a house to live in, and that's going to be your wage, and comply with the federal law, right?
No, you're right. It has to be tracked. There are all kinds of regulations. The regulations say that furnishing room and board and other facilities can count as wages, but there are certain requirements. There's another factor from Alamo Foundation that I don't know that I've mentioned that's important, and that is whether he actually was working freely and volunteering freely, or whether there was some sort of economic coercion. And that, again, this fact that the service hours were required, and if he stopped performing service hours, he could have been kicked out. That is the same kind of coercion that the Supreme Court recognized in Alamo when they found that the foundation residents were employees. This court has discussed similar factors in Benshoff v. City of Virginia Beach, where firefighters said they should have been paid for volunteer time. And the court said, well, they weren't required and they weren't asked to do that time. So they weren't coerced to volunteer. The opposite is true here. Mr. Armento was required to perform service hours. Therefore, the court should find that he wasn't freely volunteering that time.
Thank you, counsel.
The other thing I wanted to say quickly is that in Harbert v. PPE Casino, I recognize I'm out of time. If you'd like me to finish this thought, or should I?
Yes, finish the sentence.
In Harbert, the court said that another way to look at this is whether time spent volunteering or time spent as a trainee, counts as compensable work. And the focus there, if I can find it, is that work broadly encompasses physical or mental exertion, whether burdensome or not, controlled or required by the employer. So that's another framing we can look at to say that his time spent performing these service hours, which were integral and essential to the running of the ABCCM shelter, were work that should be considered compensable. Thank you, Your Honors.
Thank you.
Hello, Your Honors. My name is Jonathan Dunlap. I'm with the Van Winkle Law Firm here on behalf of ABCCM, the defendant in this case. And may it please the court, the question we would submit is much broader than whether or not Mr. Armento was working as a volunteer. The question is whether or not he had an employer-employee relationship with ABCCM. The case central to our appeal is the Steelman v. Hirsch case. That case involved two romantic partners who operated a business together. The defendant was the sole proprietor. The plaintiff worked full-time for the business, and when the relationship ended, the plaintiff sued, claiming, among other things, that she was entitled to back pay under the Fair Labor Standards Act. This court said that when considering the question of whether someone was an employee for purposes of the Fair Labor Standards Act, the court must look to the economic realities of the situation. The standard calls for a pragmatic construction of the concept of employment. The court must therefore look broadly to the circumstances of the whole activity, rather than to isolated factors or technical concepts. The court also specifically rejected the use of the six-factor test used in the independent contractor context, and the one that the plaintiff is advocating for here on appeal.
Counsel, if I could ask you, if we do not have a volunteer employer context, and we don't have an independent contractor employer context, how would you characterize the plaintiff's role here?
I would characterize it as a work rehabilitation program, Your Honor.
Yeah. That's not the answer to my question. You're
Okay.
the employer. What's the person on the other side? If he's not a volunteer, not an independent contractor.
He's a participant in this program. He's a voluntary participant in this program. The reason I think that the Steelman case is so important for us is that Steelman said when we're looking at, when we're trying to answer this question, the Steelman Court recognized the limitations on the definition of employee is not exclusive to independent contractors or volunteers or trainees. The Steelman Court said, this relationship that we have here, we don't know what to call it. We don't know what it is, but we know what it's not. It's not an employer-employee relationship. So whenever we answer that question, we don't have to specifically answer what the relationship is. As long as the answer is that it is not an employer-employee relationship, then the act doesn't apply. Now, the Steelman Court looks at the totality of circumstances, and then it asks two questions. The first question is whether the relationship of the parties has deviated from the traditional understanding of employment in fundamental ways. If it does, the court will not shoehorn that relationship into the act. The second question is whether the application of the act to the relationship will advance the act's objectives. So, turning to this case, asking the first question, looking at the totality of circumstances, what makes this relationship different from the traditional employment relationship? First, this is an artificial job market created specifically for participants of the work rehabilitation programs, or in times of shortage, community volunteers. No one here is displacing a bona fide applicant desiring to sell their services at prevailing rates. Nobody here is working for any profit-making activities. Everyone's working for the nonprofit branch of ABCCM. They don't handle, buy, or sell goods in commerce. The work is primarily oriented towards rehabilitation and improving the very place where they live. Two, this is not the competitive job market. The indispensable prerequisite for this job is a history of homelessness. This is highly suggestive of a lack of employability in the open marketplace. In fact, evidence shows the work could be done more efficiently and effectively by ABCCM's volunteers. I would also note in the competitive job market, one does not normally engage an individual in order to rehabilitate him. Instead of terminating problematic employees, they receive skilled counseling. The program relentlessly pushes workers to find outside employment. The term of engagement is fixed, it's 2 years. So no matter how efficient they become, they're replaced by someone who's not nearly as efficient, and the whole cycle starts over again. When they come in, they're told these are unpaid hours. This is not a bargain for exchange for labor for mutual economic gain. They're told that at the outset. The biggest difference between this job and a normal job is you don't even have to do it. You can opt out of it by working for someone else. You can opt out of it by just going to school, which Armento is doing, is what he did when he left the program. You can get out of it by volunteering for another organization. Here, Armento was excused from the program altogether, even though none of those exceptions applied to him for about 7 months because the program was so concerned with his lack of progress finding an outside job. People who don't do this work for the VRQ still get every benefit, free room and board, and enjoyment of all the amenities there. So there's no bargain for exchange of work for value. Residents get the value even if they're not working for the VRQ. This is all in sharp contrast to a traditional marketplace employer who would hire based on the knowledge, skill, or experience of the applicant in a bargain for exchange of labor for mutual economic gain, where employers incentivize employees to remain as long as the employee's work maintains or increases in efficiency, and where the employer would terminate any benefits of the person if he or she were to find outside employment. And once again, the traditional marketplace employers don't hire someone with the goal of rehabilitating them. So this relationship, we've answered the first question of Steelman, that this relationship deviates from the traditional understanding of employment in all of those fundamental ways. Steelman next instructs us to review whether the application of the act would further its purposes. Like the Fair Labor Standards Act, the policy of the North Carolina Wage and Hour Act is to protect those who, as a matter of economic reality, are dependent upon the businesses to which they render service. the entire purpose of the service hours program is to transition participants out of it. Otherwise stated, it's a program that's designed to reduce dependence upon itself. Applying the minimum wage protections of the North Carolina Wage and Hour Act to this program, however, would create reverse incentives. By paying participants to stay in these sheltered positions, the participants are more likely to remain outside of the enfranchised workforce and marginalized from the general public. This, in turn, directly contradicts the larger goal of empowering homeless participants to become self-sustaining members of society rather than permanent dependents of an entitlement program. Applying the North Carolina Wage and Hour Act would not likely result in getting people paid. The record will show that if they had to start paying people for service hour work, the first thing that would happen is they would reduce their services. They would no longer have, for example, the shuttle service because they don't need it to qualify for the GPD funding. It would result in community volunteers doing all this work. They would be the ones coming in and cooking for the residents and cleaning up after them. This would result in a surplus of idle time among the least employable residents of the VRQ, which in turn would lead to an exacerbation of the mental health and substance abuse issues that led so many of these people to this place in the first place. Replacing a program that helps homeless veterans transition into independence with idle time that tends to lead them into self-destructive habits would not promote the goals of the North Carolina Wage and Hour Act. Extending the North Carolina Wage and Hour Act to the service hours program would also not prevent the unfair competition that arises when businesses cut their businesses cut their costs by paying low wages. Participants in the program are not displacing a bona fide applicant desired to sell his services at prevailing rates. In fact, Land of Sky would not have permitted the SCSEP participants to hold these positions if it resulted in the displacement of marketplace employees. Service hour positions are in direct service to the nonprofit entity. Primarily, those positions, they primarily serve to improve the participants' own living space and do not result in a profit to ABCCM. Accordingly, service hour work does not give ABCCM any kind of advantage in a commercial or marketplace activity. Another point is that minimum wages are not necessary to maintain a minimal standard of living for these residents. The basic needs are met here irrespective of their ability to pay. And I would refer the court to the discussion in the Vanskigi v. Peters case, the Seventh Circuit case we've cited there. That's a prison labor case where the court decided, for among other reasons, the Fair Labor Standards Act didn't apply because it wasn't necessary to, that it would not further the purposes of the act because paying the prison workers would not improve their standard of living. The standard of living was set by their living space. Well, that's similar here. The standard of living is provided for, this minimal standard of living that these laws are intended to protect are set by the program itself. Finally, as the district court recognized, application of the North Carolina Wage and Hour Act could adversely affect a broad range of charitable activities across the state. The evidence in the case shows that there's actually a number of other programs that have come to ABCCM and they've based their program on what they've seen there. So applying the North Carolina Wage and Hour Act to programs, this program would result in the application of it, presumably to many others, and would have a chilling effect on the motivation of these nonprofits to provide programs that primarily benefit these participants, train for and transition them to stations of greater self-reliance. So just in conclusion, if you look at we follow the model of the Steelman case, and we look at the totality of the circumstances here, we first look at whether this relationship deviates in a fundamental way from the traditional employment relationship, and it most certainly does. This does not resemble a traditional employment relationship. Second, the application of the act, as we just discussed, would not further the purposes of the act, and in fact, would probably contradict the purposes of the act on some levels. I would like to touch on one point here. We talked about, I know plaintiff said if you didn't do service hours, you'd get kicked out. That's not necessarily true. As we've discussed, there's a lot of ways to not perform service hours, including what happened to Armento, where there was so much alarm in his failure to make progress in the program that they just excused him from those. But the program has a 3-strike policy. And if you get a 3rd strike, let me read you what happens from the manual. If you get a 3rd strike, the resident will receive referrals to other housing, treatment, or shelter programs and a timeline to depart the facility temporarily or until conditions are met. Our goal is to never discharge anyone to the street.
Is that all, Council?
That's all of my presentation. If the court has any questions, I'd be happy to answer them. Otherwise, I would yield the floor to my colleague.
I don't hear any questions, so we'll hear if there is any rebuttal.
I'm sorry, Your Honor. I think I had
I
15
said
minutes.
I don't hear any questions, so I think we'll see if there is any rebuttal from the other side.
Yes,
Sorry.
Your Honor.
We reserved 5 minutes for my colleague's presentation.
Right. We're about to go to that.
Okay.
Oh, you have a colleague here. Sorry.
Yes, good afternoon, Your Honor.
Good afternoon.
And Judge Floyd and Judge Rushing, may it please the court. My name is Dale Curridon, and together with Mr. Dunlap, we represent ABCCM. And as we sort of conclude, or near the conclusion of our presentation, I'd like to emphasize a few key facts that are critical throughout the analytical framework of this case. First of all, Gregory Armento did not come to ABCCM's Veterans Restoration Quarters looking for a job. He came there because he was homeless. He needed shelter, he needed stabilization, he needed a roof over his head, and an opportunity to help develop self-sufficiency and self-determination. On the other side of the coin, Veterans Restoration Quarters did not open its doors to Greg Armento because they were looking for employees. There simply was not the same exchange of labor for wages as there is in a true employment relationship. And trying to force this situation into the definition of employment under the North Carolina Wage and Hour Act is like trying to fit a square peg through a round hole. In other words, to say that the economic realities of this situation amounts to employment is really to disregard reality to a great extent. According to Reverend Scott Rogers, the executive director of ABCCM and one of the founders of the Veterans Restoration Quarters back in the late 1980s, the primary purpose of the Veterans Restoration Quarters, and this is a quote from the Joint Appendix, page 565 over to 566. The primary purpose of the VRQ is to bring homeless veterans in off the streets, to provide shelter and stabilization, and to facilitate self-sufficiency and self-determination. In addition to providing shelter, this larger mission involves addressing physical and mental health conditions, substance abuse, isolation, and a variety of other conditions that led to their homelessness. And as for the service hours program in particular, he said that it is, again, part of residents' rehabilitation. The primary purpose is for their benefit, not for the benefit of ABCCM or the VRQ. He said, and this is a quote from the Joint Appendix, page 568 to 569, "It's not just about caring for the facility, it's about the opportunity to teach them both healthy ways to relate with each other, teach them how to be responsible, and how to have healthy living standards in their own lives." With regard to the, and that was with regard to the service hours program. With regard to the temporary employment program, and this is also in the record in the Joint Appendix at page 544 to 545. He said, "The purpose of that is part of our work readiness. This provides us with a way to give residents a temporary employment along with a brief work history that we could responsibly and with integrity say to employers that they have been able to perform these duties and those duties, and it gives them confidence that they can have these residents on their job site. And these programs are successful. Recall that all of the residents of the Veterans Restoration Quarters, a prerequisite for their becoming a resident there is homelessness. So everybody there came there from a place of homelessness. And yet, as Reverend Rogers points out, 8 out of 10 of them leave the Veterans Restoration Quarters in 2 years or less with stable income and permanent housing. And considering where they've come from, not just in a place of homelessness, but all of the other factors, physical and mental illness that's been untreated, other conditions that led them to the place of homelessness where they were, is a major accomplishment, that type of a success rate. And to force that, the square peg of this situation through the round hole of the legal definition of employment would be to eviscerate a program that has proven to be effective for countless homeless veterans for over 3 decades. And Mr. Dunlap alluded to this, but when asked what would happen if ABCCM were required to pay minimum wage for service hours, Reverend Rogers said there just isn't funding to pay for that. And so when there isn't funding, what they do is they deploy their community volunteers. So you would have this absurd result where the residents, who are the ones in need of structure and community and a sense of purpose and engagement, are left to sit idle while community volunteers come in and maintain the place, cook the food, clean up, and do the things that, according to Reverend Rogers, is the very purpose of having these programs for the rehabilitation of the residents. And for those reasons, we encourage the court to affirm the district court's opinion. And I see I'm out of time. I'm happy to answer any questions the court may have.
I don't think we here have any questions. Thank you very much.
All right,
And now
thank you.
we'll have the call.
Thank you,
Counsel?
Your Honor. May it please the court, my name is Carol Brook, and together with Ms. Ripley from the North Carolina Justice Center, we represent Gregory Armento. I wanted to address the standard of review that this court should apply when considering the issues in front of it, and state that under Schultz, the Schultz factor, or the Schultz test, this court should provide a de novo review for the legal questions that are in front of it, which are the issue of whether Mr. Armento was an employee covered by the North Carolina Wage and Hour Act, and whether the district court applied the correct legal test, the Alamo test. And because these are legal questions, the court should provide a de novo review on those issues. The appellee spend very little time looking at Alamo, but the Supreme Court set out a test that looks exactly at what an employer-employee relationship is in a similar situation to what we have here. And in Alamo Foundation, the court looked at the economic realities of the relationship between the parties and said that where there is an economically dependent relationship in which there is an element of economic coercion and an expectation of compensation in the form of room and board, that the person at question is an employee and is not a volunteer. In this situation, we have more. We have Mr. Armento being paid by ABCCM $9 per hour, supervised by an ABCCM employee who performed work essential to the mission of ABCCM to provide good services at the Veterans Restoration Quarters. He was recruited for his job because of his skills and because of ABCCM's need. That evidence is found in the joint appendix at page 752. And ABCCM referred to Mr. Armento as their employee. They in fact stipulated to that relationship being an employer-employee relationship. Then ABCCM required Mr. Armento to do identical work that was unpaid. And ABCCM determined, in fact, when it would and would not pay him during the same work week. The goals of their unpaid work program don't matter. It's admirable that ABCCM is a charitable organization that provides important services to the veterans community in Asheville. But what matters as a matter of economic reality is that Mr. Armento was their employee. There was a bargain for exchange here. He performed many hours of work each week for pay. But even when he did not perform work for wages, he performed work in the expectation that he would continue to receive room and board from ABCCM. Did ABCCM provide room and board for persons who did not perform paid work for them? Yes, they certainly did. That's not the issue in front of this court. But if the court does want to consider that issue, it should follow the Alamo Foundation holding as well and look again at whether there's an economically dependent relationship based on the expectation of compensation in the form of room and board and an economically coercive situation. Here with a homeless population of veterans who are needing to leave the shelter within a specified time period, they are clearly economically in need and economically dependent on the shelter for their room and board until such time as they leave.
But as I understand the record, your client could go work for somebody else and that would be fine with the board.
Yes, Your Honor, that's correct. He could work for another organization, although the record does not show that many people did do that. But he could have done so. However, if he had done so, then he would not have been in an employment relationship with ABCCM. Here he did work for ABCCM and he did work that furthered their mission. He did work in expectation of compensation from them. That he could have received that compensation without working for them directly is immaterial. The fact is that he did work for them. There has been some discussion of whether the fact that the work was not available in the competitive job market is an issue. And I would submit that usually those discussions are in the context of whether the Fair Labor Standards Act is involved, whether there's interstate commerce involved. And that's not an issue in this case. We're talking about the North Carolina Wage and Hour Act. Because Mr. Armento's work was essential to ABCCM's mission as a nonprofit, it was part of their job market. They said that they would have to find someone else to do the work if he did not do it, whether it be a volunteer or somebody who they hired, the work would have to get done. And so it was work that was essential to their operations, and the act was intended to cover it. The act was certainly intended to cover these relationships of unequal bargaining power. And the situation of a homeless veteran who is dependent on an organization for his very survival in some instances surely shows and surely is intended to be covered by the Fair Labor Standards Act and the North Carolina Wage and Hour Act. These persons need a place to live and they need a wage that allows them to eventually move out and be self-sufficient. In terms of the chilling effect that Judge Rushing, I believe, asked about, there is nothing to stop ABCCM from using community volunteers. Community volunteers would not be in an economically coercive relationship with ABCCM. They would not be expecting compensation. So there should be no reason why other nonprofits or religious organizations couldn't turn to community volunteers, as ABCCM does quite properly, and not be expected to pay them. Finally, I just wanted to say that the North Carolina Wage and Hour Act applies when there's an employer-employee relationship unless there is an exemption. Nonprofit organizations are covered by the act. There is no exemption for rehabilitative work. There is no exemption for volunteers where there's an employer-employee relationship. There is an exemption for prisoners, and there was some discussion of a prisoner case, which is inapplicable because the standard under the Fair Labor Standards Act is different. But because Mr. Armento was in an employer-employee relationship under the Alamo Foundation test and under the economic realities of the situation, we ask that the court decide in his favor and remand to the district court for findings as to damages. Thank you, Your Honor.
Thank you very much. Counsel, we appreciate your arguments on both sides, all counsel. And as you know, in the Fourth Circuit, we usually come down and shake hands at the end of the argument. Obviously, we can't do that today. Right, exactly. But we are very glad to have you here. And we hope soon this will all be a distant memory and not reality. Thank you very much for your arguments.
Thank you.
Thank you, Your Honor.
And can we have court adjourned?
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.